Oh my God. Okay. There will be a timestamp for you to skip through all this intro while I'm waiting on everybody to come in. Cause now I got this doggone of all the times. It's over here getting visited by stormtroopers and stuff. Okay. Okay. Thank you for liking the video, Miss Queen Liz. Okay. Let's go ahead and start. So what I have is a kind of a three-parter because I have the original petition from Kandi, then we have the response from Todd, and then Kandi's amended petition. So we have three documents we're going to go over. So first we're going to start with Kandi's original petition and where she tried to keep it real clean, and it's just we'll go by the prenup, and we split time with the kids, no issues. So we'll start there and we'll see where it goes. So petition for divorce, the original one that Kandi filed, it says, comes now the petitioner, Kandi Tucker, and files for her petition for divorce against respondent T. Jermaine Tucker. My brain keeps emphasizing Jermaine. Petitioner is a resident of Fulton County, Georgia, and has been a resident of the state of Georgia for at least 6 months preceding the filing of this complaint. Respondent is a resident of Fulton County, Georgia, and is subject to the venue and jurisdiction of this court. Personal service may be effectuated upon the respondent at his current residence in Fulton County, Georgia. Petitioner and respondent were married in April 2014. Okay. The parties separated on or about July 15th, 2025, and have lived in a bona fide state of separation since that date. And I just think about when Kandi just got the housewife award and all that was going on, and they was already legally separated. Oh my gosh. Okay. It says there are 2 minor children born as issue of marriage between the parties. Petitioner shows that said minor children have resided with the parties from birth up until the date of their separation, and there are no other proceedings involving the custody of the minor children. Petitioner knows of no individual other than the parties to this action which may have any claim of custody or visitation rights concerning said children. So just her and Todd. The minor children have been in custody and joint control of both parties. Petitioner believes that it is in the best interest of the minor children for the petitioner and respondent to be awarded joint physical custody of the minor children. Now, once we get to Todd's answer to her petition, we'll see Kandi's amended petition where paragraph 7 is no longer going to look like paragraph 7 anymore. It says the petitioner believes it is in the best interest of the minor children for the parties to be awarded joint legal custody of the minor children. If you hear beeping, it's my baby Yoda Tamagotchi, and I apologize. Okay. Petitioner is entitled to a divorce from respondent upon the grounds that the marriage between the parties is irretrievably broken as contemplated by OCGA 195313, there being no reasonable hope of reconciliation. Petitioner asserts that the parties prior to marriage entered into an enforceable and binding prenup agreement. Therefore, petitioner requests that said prenup agreement be enforced by this honorable court and the terms therein be incorporated into a final judgment and decree of divorce on behalf of the petitioner and respondent respectively. Parties possess debts that have been incurred throughout the duration of the marriage, which should be subject to equitable division directed by the prenup agreement. The petitioner asserts that child support obligations for both the petitioner and the respondent be determined in accordance with the child support guidelines of the state of Georgia, respectively. The petitioner asserts that the parties shall be responsible for their respective attorney's fees and costs. Wherefore, petitioner prays that she is awarded a total divorce from respondent, that summons and process be issued as required by law, that the petitioner is awarded joint physical custody of the parties' minor children, that the petitioner is awarded joint legal custody of the minor children, that the parties' child support obligations be determined by the child support guidelines of the state of Georgia, the prenup agreement is enforced on behalf of the petitioner and the respondent, and that the petitioner is granted any such other and further relief as the court deems equitable or appropriate. Hey, Jay. that the petitioner is granted any, okay, I think I already read that. This, the 21st day of November 2025. Okay, so now that was Kandi's first filing. Let's keep it clean. We split time with the kids. We go by this prenup. No muss, no fuss. That's how I took how Kandi filed her first version. Okay, now we're going to go to Todd's request. Let me see if this is it. Nope, that's the amended one. Hold on. Todd's answer. Okay. The answer and a counterclaim for divorce and other relief. It says, comes now respondent T. Jermaine Tucker, by and through his counsel of record, Randall M. Kessler and Asia Hayward James of Kessler and Solomini, and files this his answer and counterclaim for divorce and other relief. Overview. Respondent T. Jermaine Tucker and petitioner Kaylanice Tucker were married on April 4th, 2014. On that same day, a purported prenup. Now, see, he doesn't just say prenup agreement. He says a purported prenup agreement prepared by wife's attorney, had to point that out, was presented to husband without husband having counsel, is what he's saying. Even though wife's then counsel had communicated previously with the undersigned regarding a potential prenup agreement. This is where I have a problem with Todd, and I don't really do too much because Todd has had to endure a lot from Mama Joyce as well. So I don't do too much with either one. Like they knew what they was getting into, and they made their choices. But you cannot convince me that as a grown, mature man that already had a kid before she's grown out the house, that a pre-nup, pre the nuptials, wasn't going to have to be signed before y'all went up on that altar and said, I do. Like, to me, I would think that you would be more aggressive with your attorney going to her attorney and saying, hey, we got to iron this out because now, we're getting close to the wedding day. And I know she wants me to sign it. So to me, we're planning to always say you signed it under duress, because at what time do you sign a prenup except for mostly prior to the nuptials in the first place? So that's where I Todd on that part of, I didn't know they were going to present it to me. Well, when else do you present it but before y'all get married? Okay, I'm going to get back to the document. All right. So it says the minor children are currently in husband's care and residing with him in Georgia, while wife's out-of-state work obligations have required and will continue to require her to be away from the children for at least the next several months. The parties have been working cooperatively in an effort to resolve all issues, and husband remains committed to continuing those discussions in good faith. However, in the hopefully unlikely event the parties are unable to reach a full agreement, husband shows that he will seek an award of primary physical custody, joint legal custody, and final decision-making authority, with wife having substantial time and meaningful access to the children. So he wants primary, so they stay with him, the primary. No, Kandi's first filing said, I just want joint physical, joint legal. I don't remember what she said as far as final decision-making in her first petition, but I can definitely tell you what she said in the amended one. And but Todd wants primary physical, and he wants to be the final decision maker when it comes to the kids, with wife having substantial time and meaningful access to the children. Husband wishes to make clear that he recognizes wife as a loving and capable parent and remains sincerely hopeful that prior and continued discussions between the parties will bring full resolution of all matters. First defense. Husband affirmatively shows that petitioner's petition for divorce is procedurally deficient under OCGA 1955. This is where I feel like his attorneys were like, go ahead and file a response, but we need to buy some more time. So we got to find something that she didn't do proper, or something we can at least raise a question about that she didn't do properly. And it was a minor one to me, but if it's required, it's required. It says petitioner failed to verify the petition as required by subsection A, state the residence or last known address of respondent as required by subsection B1, and provide the name and age of each minor child as required by subsection B4. Husband reserves all rights to challenge the sufficiency of the petition based upon these statutory deficiencies. So it's so minor that I'm just like, this sounds like you just need to buy time. I'm about to turn my screen off for just a second because so let me see where in here. They list the address in here and I don't want to accidentally put that up there. It's publicly out there now, but if I can help it, I'm not going to put their address up there on purpose. So the document will come back on the screen when I know I've safely passed that page. So it says, husband admits the allegations contained in paragraph 1, 2, 3. Basically, he neither admits or denies allegations from paragraph 4. And there were no like allegations in the sense of she said he did anything wrong. He's just agreeing to the date they got married that she said in her petition, stuff like that. So we're going to keep going. And then it says the allegations, contained in paragraph 7 require no response. The allegations contained in paragraph 8 require no response. But it says husband admits that it is in the best interest of the minor children for the parties to be awarded joint legal custody of the minor children. So joint legal, they agree on. Joint physical, they don't agree on. And we'll get down there. I'm trying to get past this address. I know as soon as I bring the page back up, if I don't get past this address, I'll be showing it to y'all. Okay. More of required no response. So I'm just going over those because it's the standard legal jargon. Okay. Now, the counterclaim for divorce, and I'll just show y'all this screen because it doesn't have their address up there yet. But this is where he has answered her petition for divorce, and then he has now also filed his counterclaim for divorce and other reliefs. That's what I'm looking at right now. All right. So I'm going to take it back down until I get past that address, though. So it says, comes now T. Jermaine Tucker, respondent husband, buying through his undersigned counsel, and files this, his counterclaim for divorce and other relief, respectfully showing the court as follows. He's resided in Fulton County. The petitioner is also in Fulton County. They were lawfully married on or about April 4th, 2014, and they are currently living in a bona fide state of separation. And if you came in later, they have been separated since June of 2025. Then he says there are 2 minor children born as issue of this marriage, to wit, and then he names the children, whereas I don't think Kandi named the children in the first one or their ages or anything, but you have A. Tucker and B. Tucker. And then it says, husband shows that he should be awarded temporary and permanent legal custody of the party's children, as well as final decision-making authority. Husband shows that he should be awarded, this is another paragraph, it's going to sound the same. Husband shows that he should be awarded temporary and permanent primary physical custody of the children. In the event the parties are unable to resolve all issues privately, the court should determine all matters related to the minor children in accordance with OCGA 1993 and 19615. Okay, now I can get past this address. And I can bring my screen back up. 1 second here. Okay. All right. So it says, husband has not participated as a party or witness or in any other capacity in any other litigation concerning custody of the party's minor children in this or any other state. Husband has no information concerning any other custody proceeding concerning the minor children presently pending in any other court in this or any other state. And husband knows of no person, not a party to this proceeding, who has physical custody of the minor children or claims to have custody or visitation rights with respect to said minor children. In the event the parties are unable to resolve these issues at mediation or otherwise, husband requests that these issues be heard at the 30-day status conference scheduled for January 12th, 2026, or in the alternative, that this matter be scheduled for a temporary hearing at the court's earliest convenience to address temporary custody, parenting time, and all other temporary issues necessary to promote the best interests of the minor children and to ensure clarity and stability for the parties pending final resolution of this action. Let me take a breath. Okay, let me see here. Husband is entitled to a divorce from petitioner on the ground that the marriage is irretrievably broken as defined in OCGA 195313, and there are no prospects for reconciliation. Husband is further entitled to a total divorce or divorce a vinculo matrimony, while husband remains hopeful that the parties can resolve all issues amicably and privately. Husband expressly reserves the right to assert and add additional grounds for divorce as permitted by law. Husband shows that the parties signed a prenup agreement dated April 4th, 2014, immediately prior to the wedding ceremony. Petitioner's counsel at that time was fully aware that husband was represented by the undersigned and has been actively communicating with his attorney regarding the terms of a potential prenup agreement. Despite that knowledge, petitioner's counsel presented the final agreement to husband for signature immediately before the wedding ceremony, without any notice to or consultation with the undersigned counsel, who had been significantly engaged in the negotiation process. These circumstances raise substantial questions concerning the enforceability of said document. Nevertheless, husband remains committed to working in good faith to resolve this matter amicably and privately to the extent possible. My question is, when did you think the prenup was going to be signed? Why didn't you try to revisit it with your counsel? Let's say you signed it, y'all got married. Why didn't you revisit that with your counsel and her counsel right after y'all did your vows, like a couple weeks after? Like, I just have questions on that one. During the course of the marriage, the parties have acquired various assets, known and unknown to husband, tangible and intangible. Husband should be awarded an equitable division of all marital assets, both real and personal, tangible and intangible, between the parties. Husband shows the court that he should be awarded his separate property and any appreciation thereon. Husband shows that the parties have acquired debt throughout the course of the marriage. Husband requests that such debt be equitably divided. I have a few opinions on it being like splitting the marital assets. Once you're married, what y'all gain together, I get that 50-50. What comes into question, and I would love to know what the court ends up deciding at the end of all this, is how much played into the businesses would not be as successful if people didn't know of Kandi, versus is it just, it doesn't matter post April 20, whatever day they got married. If anything else they gained, that gets split 50-50 because that's when they were together. And I do try to look at it as if Todd had been the breadwinner and Kandi had been the wife that came in after the marriage, supporting him, and more things happened. But he was already famous though. But we, for the most part, it's accepted that a woman leaves with whatever she's able to leave with, minus what the prenup says though. So if the prenup already has stuff, we're like, hey, you signed that prenup. So that's what I am with Todd. If you sign the prenup, just stick to the prenup. But yeah, so we'll see. And I think that's why, because I think it gets very specific in there in that prenup, is what I'm guessing. Because otherwise it wouldn't be important. So we'll see though. I just have questions. I don't really have a strong stance either way. All right. Let me see. So now we're in husband shows that OCGA 1957 provides as follows with regard to the transferring or disposition of property. After a petition for divorce has been filed, no transfer of property by either party except a bona fide transfer in payment of pre-existing debts shall pass title so as to avoid the vesting thereof according to the final verdict of the jury in the case. So don't go selling off stuff, don't go hiding stuff. That's basically what I got from that. Okay. Further, wife is bound by the provisions of the OCGA 1961E, which provide as follows with respect to the transferring or disposition of property. Pending the final determination by the court of the right of either party to alimony, neither party shall make any substantial change in the assets of the party's estate, except in the course of ordinary business affairs, and except for bona fide transfers for value. Husband insists that petitioner comply with the foregoing statute in all respects. Petitioner is put on notice of not only the law of the state of Georgia, but also on notice of husband's intent to insist on full and absolute compliance by petitioner. Husband hereby places petitioner on notice of the following important provision regarding spoliation of evidence. You are hereby notified that Georgia law requires you to exercise reasonable care to protect and preserve evidence relevant to the issues in this case/action. By this notice, you are hereby given notice not to destroy, conceal, or alter any video, audio, paper, or electronic files or other data in connection with this pending litigation, including but not limited to any of the following items that are either presently in your possession or control, or which may come into your possession while this case is ongoing: any financial records or statements, all income records, all tax records, all expense records, all recordings or evidence reflecting relevant conduct by either party, any item that supports any defense raised by you to this petition, and or any item which supports any claim made by you in any counterclaim or pleading filed in this matter. You are further notified that a failure to comply with this notice may result in sanctions for any destruction or failures to preserve any such evidence, including without limitation adverse inferences against you at trial, as well as an award of expenses and attorney fees necessitated by such conduct. And then it lists previous cases that are relevant for that. It says, husband is hopeful the parties will reach an agreement settling all issues pending between them. However, if such an agreement cannot be reached, husband reserves the right to amend this counterclaim accordingly. Husband requests that the court incorporate any settlement agreement entered by the parties into a final judgment and decree of divorce. So wherefore, husband respectfully requests that a rule nisi issue requiring petitioner to show cause why the temporary relief requested in husband's answer and counterclaim for divorce and other relief should not be granted, that he be granted a total divorce from petitioner upon legal principles, that is, a divorce a vinculo matrimony, that husband be awarded legal custody, final decision-making authority, and temporary and permanent primary physical custody of the children as determined in the children's best interest. That the court determine all matters related to the minor children in accordance with OCGA 1993 and 19615. That husband be awarded an equitable division of the marital property of the parties and to be awarded his separate non-marital property and all appreciation thereon. That the parties equitably divide all marital debt. That husband be entitled to all additional relief, including alimony and child support in the event that the prenup agreement is not enforced. Of course on that one. That the court incorporate any settlement agreement entered into by the parties into any final judgment and decree of divorce, and that husband be awarded such other and further relief as this court deems just and equitable. Respectfully submitted this 26th day of November 2025. Okay, so two main things that I see from Todd is he wants primary physical custody and he wants final decision-making authority when it comes to the kids. He wants alimony. He wants child support. And I definitely believe he does not want that prenup enforced. That's what I'm getting. Now, we do have Kandi's amended answer to his counterclaim in his response. So I will pull that up. Let me see. Is this it? Okay, yeah, that's it. Okay. So Kandi, she did it really clean and plain the first time. The second time, she was like, okay, that's what we're doing. So as you can see, amended petition for divorce. And it'll have the date at the bottom. But I think it was December 1st, I believe, that she filed it. But we'll get there. So Kandi's new response is petitioner and respondent were married in April 2014. Prior to the date of marriage and conduction of the marriage ceremony, the parties drafted, negotiated, and executed an enforceable prenup agreement under the applicable statutes of the state of Georgia. So it's going to come down to the judge deciding if they're going to enforce that prenup, or are they going to say it was signed under duress and they come to a different agreement. Attorney Randall Kessler represented the respondent, and he provided legal counsel and direction to the respondent during these considerations on and off camera. Further, the parties' journey to executing an enforceable prenup agreement was filmed and broadcasted on Bravo Television Network with the knowledge and consent of both the petitioner and respondent for their 5-part reality television wedding documentary entitled Kandi's Wedding that premiered on June 1st, 2014. The respondent audibly announced during this documentary that he was indeed, quote, good to sign the prenup agreement during a private encounter with the petitioner and after consulting with his attorney, Randall Kessler, on and off camera. And then Kandi corrects her part where, Todd's attorneys, they said her petition was deficient because it didn't state the children's name and when they were born. So she corrected that. Then it says, both the petitioner and respondent are public figures and self-employed entrepreneurs. This is the part that's important because Todd is using Kandi's travel to say he should have primary physical custody and the final decision-making authority. So Kandi's like, okay, let me change. Let's incorporate both of our careers in what we've been doing. So both the petitioner and respondent are public figures and self-employed entrepreneurs who work in the metropolitan area and throughout the United States. During the periods of time that the respective parties' work schedules required them to travel, the petitioner has hired and paid the expenses for a full-time nanny. The nanny has provided care and assisted the parties with the minor children throughout the marriage and since the respective births of each of the minor children to date, without any objection from the respondent. So Kandi's saying it's been good for the goose while we were married. It should be good for the gander now that we're going to get a divorce. If you're okay with a full-time nanny when you could have stayed and been watching your kids or you wanted primary physical custody, then you should be okay with a full-time nanny now that you and I are no longer together, but we're still operating how we've been operating when it comes to the care of the children. That's how I'm taking it. This is my opinion. I'm interpreting this. Okay. So then it says, let's see. Both the petitioner and respondent have held professional obligations that have required each party to travel away from the home for extended periods of time, independently and jointly, prior to and after the births of both of the minor children. So Todd has to travel with and without Kandi. Kandi's travel with and without Todd. This would not be anything new. She didn't all of a sudden get these jobs that make her travel. Okay. And same for him. He's been traveling too. In addition to the nanny service, the petitioner has a diverse and concentrated family support network, which includes maternal grandparents, aunts, uncles, and cousins within a 5 to 20-mile radius of the family residence. The petitioner support network is readily available, and has traditionally supported the minor children emotionally and physically throughout the marriage in accordance with the petitioner. Therefore, the petitioner amends her petition and asserts, in accordance with OCGA 1993, that it is in the best interest of the minor children for her to be awarded primary physical custody of the minor children, with the respondent being awarded parenting time with the children on a consistent basis and in accordance with the parenting plan. So now that Todd sat there and he said, I want primary physical custody and I want to be the final decision maker, Kandi's taken off the table where she was like, oh, joint. Of course, we'll decide things together and we'll be good to go. She's like, okay, well, now I want primary custody and I want to be the final decision maker and you can have good, consistent time with your children. So now this is unfortunately, the gloves are coming off because she did not reassert, I just want to do joint. Now she's saying, no, I'll take it then. So we'll see what happens. It says the petitioner reaffirms that it is in the best interest of the minor children for the parties to be awarded joint legal custody of the minor children, and further asserts that it is in the best interest of the children for her to be awarded final decision-making authority with matters related to academics, education, and healthcare. Wherefore, petitioner prays that she is awarded a total divorce from respondent, that the petitioner is awarded joint legal custody of the parties' minor children with final decision-making authority with matters addressing academics, education, and healthcare on a temporary and permanent basis, that the petitioner is awarded primary custody of the minor children on a temporary and permanent basis, that the parties' child support obligations be determined by the child support guidelines of the state of Georgia, that the prenup agreement is enforced on behalf of the petitioner and the respondent, that the petitioner is granted any such other and further relief as the court deems equitable or appropriate this first day of December 2025. So now, unfortunately, they are going to be in the battle of primary custody, final decision maker. Todd doesn't want the prenup to be enforced. And I just think as a mature, older man, not older than her, I'm just saying a man that is seasoned in this world, why did you not readdress this, if that's the thing that can be done, to readdress the prenup early into the marriage, within the first 90 days of being married? Like, why are you saying it shouldn't be enforced now that she has filed for this divorce? I just think that there's a certain level of proactiveness that you should have. And also, before that point, why weren't you like, we can't set a wedding date until we agree on the prenup? Like, how did you get yourself down this aisle? Like, you're there too. You're an autonomous being. So that's the part I don't understand. I am not surprised that he wants alimony, child support. I'm not even sure if I'm criticizing him for wanting it, because if you marry someone that makes less than you, you kind of got to expect, except, with the good prenup, which Kandi did try to have, that there's going to be you giving out the money. Like, that's kind of going to come with it. So we'll see what happens with the prenup. So I'm not surprised he's asking for it. It's the whole point there was a prenup, because she probably knew he'd want some things too that maybe he didn't really, in her mind at least, earn with her or deserve. And I mean, even the discussion of the fact that she knew if she passed away and they were still married, that she could not give him power over the finances because she didn't know if Riley would be taken care of, is scary. That's very scary to even have to think about that. So they went in making their own decisions. They knew, to me, what they were getting into. On TikTok and probably now on YouTube, people have clipped out some conversations that Todd and Kandi used to have while her makeup artist and her hair person were doing her hair. It's some sideways things that Todd has said, and it's some sideways things to me Kandi kind of allowed and played into. So it's very interesting to go back now and hear those things and watch those things as they're now going through this divorce. So I would say, if you're interested, that would give some really good insight. I don't know if he implied it or he actually said Portia, but there was a conversation about how he doesn't think it'd be wrong if they didn't make it and he slept with one of her friends. It was weird. And then it was weirder because her hair or makeup person was like, yeah, wouldn't you want him to be with someone that, that you already know is kind of cool, and that way they know that they get along with their kids or something? She was saying, like, this is weird, and why are you advocating for this? You're weird. So it's some interesting conversations to go back and look at when it comes to Todd and Kandi. But yeah, paints a crazy picture. All right, so that's all I have. I'm here for your document read-throughs, little bit of commentary, but mostly the documents. So I thank you for your time, for sitting through this. Just hit the replay if you didn't see everything, and I hope y'all have a great night. Talk to you later. Bye.